I'm enjoying talking with you today. It's a relaxing day before the 4th of July. My grandmother, Lola Sarah Filson Hunter, was born in 1884 on this day. And it's also a day that was right in the middle of the Gettysburg Battle. So it's a significant day. And of course, tomorrow is a day that I look to with mixed feelings given the great political controversy. I don't know how to transition that to the subject I'm going to talk about, except to say that if there's one subject that conservative political media, big industry, big insurance, big pharma, and basically those in power like to demonize, it's people like me. I was an Eisenhower and George H.W. Bush and George W. Bush Republican once upon a time. I've evolved, and let's just say I'm a more moderate. I'd like to think a little wiser. But I do like to bring out the truth on a particular subject. If you're rear-ended by somebody that was texting, or you're forced off the road and into a tree by somebody who was drunk, or there's somebody who's talking to their their adult child on Facebook, and look up and they see the green arrow light come on and go straight through the intersection and cream you in the side and roll your car, wouldn't you want to be able to get a just result? And wouldn't you like to know what a just result is? Well, think about it for a minute. You got plenty to worry about. You've got an elderly relative that you provide care for, and an instant later, through no or little fault of your own, you're in a rollover collision. Think about that. I'm sorry I had the gap in time, but I want you to think about that, because you don't just get your medical bills paid. As a matter of fact, it gets a little complicated. Maybe you have MedPay coverage on your car. So up to $5,000 or even $25,000, your medical bills are paid by your own insurance. Ironically, if you also have a medical card or Medicare or some plan that doesn't get paid full payment, their subrogation claim could be a lot less than your own insurance company's subrogation claim. What is a subrogation claim? When the other person causes the collision and you have insurance, there'll be a provision in that insurance, whether it's government insurance or private insurance, that the innocent carrier, your carrier, can get reimbursed out of your settlement. So if you got a $25,000 settlement, you may very well have an $8,000 subrogation claim. It gets a little complicated. If the plan that is trying to recover is an Erisa Plan, which is a federal, Employment Retirement Income Security Act or something like that, they have a very strict policy. They want to get paid back in full. If you've got a $19,000 settlement and there's a Medicaid lien, and the medical bill was $10,000, but Medicaid only paid your medical provider $3,000, that gets a little complicated because your provider really doesn't want to accept your insurance, but they have to. They can't sit back and say, we want to get paid by the tortfeasor, because they don't have a claim that they can approach that way. So we can really help a client who gets that $19,000 settlement, because the Medicaid claims and certain other claims have a limit of $20,000. Or if it's a claim against a school district, such as a negligent school bus driver, those are exempt, even if they're over $25,000. So it could be that the $3,000 or $4,000 Medicaid subrogation claim is waived completely. Also, if you get a net sum, say $12,000 cash, you're not eligible for Medicaid. So what do you do there? What we do is, when we receive the money, we can hold for an appropriate short time before we distribute the funds, and then we can give you the funds after we've put together a plan for a spend down. You are allowed to pay back due bills. You are allowed to prepay your rent or your utilities. You're allowed to invest in a decent, safe vehicle. So at the end of the 30-day period, when it's your duty to report to your Department of Health and Human Resources representative that you received this cash and you've got yourself spent back down under $2,000, you won't lose your eligibility. We met a nice gentleman not too long ago. He was terrified because he had $5,000 or $6,000 in medical bills. His carrier wouldn't accept his medical card. He thought he was going to get sued. He's a gentle soul with a cognitive deficiency. And just telling him that we wrote a letter and that the medical card's going to take care of his bills was worth hiring me. Now, I haven't made any money yet, and I'm still trying to get a resolution for him, but that is very important to certain people. Now, let's take that rear-end collision, $5,000 or $15,000 or $50,000 in medical expenses. One thing I want you to do is pull out a pencil. You got it? Got one? And consider writing down that I wrote something called Insurance Roulette. And it's my critique of all these ridiculous, humorous insurance advertisements. The black gentleman with the deep voice who promises to save you money, and the Geico Gecko and Flo and Jamie, her crazy sidekick, and now the snarky girl that gets on Jamie's nerves, and mine too. That information, oh, and the Liberty Mutual's, I want to call it an ostrich, you know who I'm talking about. All of that stuff is baloney. What they're trying to do is compete for the basic coverage, sell you the littlest amount of insurance you can, and maybe later upsell you. I don't know what they do once they've got you to hire them. But anyway, I've written an article explaining to you how important it is that you have insurance coverage on yourself called uninsured coverage and underinsured coverage. And if you're a person of some means and you have a house worth 6 figures, you have retirement funds, you have a career, but you would be devastated if you were off work for 6 months, you need something even more robust, and that's called a personal umbrella. I hope you will find time to review that article. It goes into considerable depth. The first time through, Facebook said it was too controversial because it might make some of these big moneyed companies unhappy with Facebook. So even though Donald Trump can retweet certain racial comments from the villages, Bert Hunter's little whistleblowing thing had to go through a couple processes before I could get it posted. But I do have it, and I think it's a good post. And the way you get to it is you go to www.hunterlawfirm.net, or you could put /blog, or you could just click on the button to view Mr. Hunter's blog. It's one of the most recent articles within the last 3 or 4 articles, so you can just scroll down and read it. So back to my job. As soon as I hear you've had a collision, if it's clear-cut, no controversy about how the collision happened, I may not visit the scene immediately. But if there is some question, the other side says the light was green and you think it was red, whatever, I will go out. I will use my skills, because I do have photography and video skills, as as little as they are apparent here, when I'm on the other side of the camera, I can do okay. And I'll interview you. I will send that interview to my paralegal. We have a checklist, probably 20 things we do in the first week after we get a claim like this. We compete in a very effective way, I believe, for clients, because if there's no controversy over fault, and it's a pretty straightforward thing, we don't charge the standard 1/3 or even a quarter. We're able to charge 20%. That's 1/5. And with the work we do compromising or getting waived your subrogation claim, we can net out to you more money, I believe, than most firms. I'm blessed to have a paralegal of nearly 20 years who takes her job very seriously. If you check my reviews of J. Burton Hunter III, you'll find Letitia and Faye mentioned a lot in my post, because I am the face of the firm, but they are the heart. They are the people who translate what I explain to people, sometimes without the patience I should do, and they're the ones who work with people day in and day out. I am not remote. I am not difficult to reach. They will make sure that you and I can get on the phone or get in the office quickly when you need to. We have you keep a diary. We have a letter that we send to your friends and family. If you've had a serious injury that's changed your personality, your capabilities, your mood, and they've been able to observe that, this letter goes to them and explains, we want to tell that story to the insurance adjuster. Could they talk about what you were like before the collision and how you have been since? We had one where the woman who already had some serious disabilities, impairments, was the biggest volunteer in her church. Everybody loved her. After her injuries, she became a virtual recluse, and they noticed and they talked about it. And those letters help our clients recover, because they know people love them and care and want them to get better. I had one where my client she's a very tough cookie. She never complained. She had a deep religious faith, and she told me that nobody would have noticed anything different about her because she had hid it from everybody. Well, they didn't know that she wasn't hiding it too well. She was being brave. She wasn't complaining, but she had changed in myriad ways, and reading those letters brought tears to her and to us, and opened a whole floodgate of potential recovery tips and solutions. So those things can really help. Now, I talked about the underinsured and uninsured motorist coverage. That gives coverage to the other side. That is, the person who hits you, who has little or no insurance, can all of a sudden have $100 or $200 or $500,000 per person. And if you get yourself a personal umbrella on top of that, then you can have $200,000 per person, $600,000 per occurrence, which means if you and your family are in a car hit by a drunk driver, there might be $600,000 available to pay for you as a family for your various injuries, plus $1 million umbrella on top of that. I have been able to collect more than the full coverage of the umbrella and the underinsured motorist coverage within that limit, but into the 7 figures, and it literally was a lifesaver. Otherwise, there would have been bankruptcy, there would have been the end of a family business, there might have even been a nervous breakdown or a heart attack, because these folks had to fight to come back, and they did, and they're friends, and I hope they're well today. So even a routine fender bender that turns into a month of physical therapy, a few weeks of chiropractic care, a permanent GIMP, a permanent limp, or a bulging disc, and of course if it's a broken bone or a disfigurement or something called a mild closed head injury. I wrote an article called The Chinese Curse. You know, they say, may you live in interesting times, and that can be a curse given some of the events of history. Well, may you have a mild closed head injury means may you have something that scrambles your brains, causes microscopic tears, changes your personality, interferes with your short-term memory, tremendously harms your ability to concentrate, and requires specialized treatment, perhaps in Pittsburgh or one of the more remote facilities, Johns Hopkins, or the Cleveland Clinic. That's what I was struggling with. Those facilities may need to be involved. If so, what seemed to be a relatively mild impact may make a person unemployable and can be treated in a very effective way to get most of those symptoms under control. I've been doing that since I was an Air Force claims officer, managing 60 cases at a time at Griffiths Air Force Base for 4 years, and buying a book as soon as I got out, a practice management program for personal injury, putting together dozens of forms, handouts, and articles and recordings, trying to educate people on what we can do for them. Then there's another category of case. You may have heard about the Sago mine. We were co-counsel with the Charleston firm there, or cases with $500,000 in medical specials, or complex med-mal, or industrial accidents, as I just referred. By going to dozens of professional meetings and seminars, I have learned the attorneys that have the best reputations for such cases. And when I have a case that I feel that our firm might not have the resources to put out the $50,000 or $100,000 in litigation expenses, we are able to associate with other firms. That gives you a local counsel with a vast amount of experience and sort of a sounding board, and also a bit of a cheerleader if the firm that we associate with is caught up in something else. We can help get their attention. It's been a wonderful experience for us in dozens of cases associating with myriad 5, 6, and 7-figure settlements. And we're happy to do that. Guess how much more the attorney fees is on those cases? Nope, that's not right. It's the same. So if the standard fee for such a matter is 1/3, or in certain complex cases 40%, we take our share of the fee from that standard figure. So if you come to me and we record your interview and we help curate it and get it to the right attorney and they accept it, you don't pay anything extra, but you have 2 attorneys to contact. Sometimes we stay intimately involved from beginning to end, especially if it's right near where we are practicing. Other times it pretty much is handed off and the other side takes sole responsibility. The key is transparency. We make sure that you know that. I hope this has helped you get a feel for the importance of an attorney in what appears to be even a routine case. Remember, the insurance adjuster does not get promoted. He doesn't get bonuses. She doesn't get the pat on the back or the career opportunities by giving away money that they could otherwise keep for themselves. They are profit-making enterprises. They're not charities. But they do have hearts, and I don't really like the ones that has the insurance adjuster looking like an evil, maybe has horns coming out of the back of the head. Most of them get up and go to work and try to do a decent job, and if you treat them respectfully and give them the information they need, sometimes they'll come through with you for that extra $5,000, arguing with their supervisor that you really don't want to mess with Hunter in court, with a local jury, that his people that he knows how to talk to. But let's get back to the fact that there's a tremendous industry involved in wanting you to think that you don't want to go to a lawyer because that lawyer is greedy. That lawyer cares only about himself. A good lawyer is going to care about himself, and I've done this before, quite a bit. Himself, his family, his reputation. And if you think personal injury lawyers don't have egos and drive and competitiveness, then you'd be wrong. They are the peacocks of our menagerie. But the good ones always put you above that. Get it? They benefit, we benefit by getting a good settlement. But it can't be at a cost of our client's interest. We take an oath. We are licensed to put you before ourselves or our families. And the good lawyers do that. And they're really passionate for what they do. So this took a little longer than I wanted, but I hope it's got some information that you can use.